Welcome, everyone, to Trials and Errors, this time co-produced here at the New York City Bar Association. Helen Herman, she did not say this, but she was the original executive producer for the Forum on Law, Culture, and Society, and that's one of the reasons we're here and will continue to be here in support of our friend. Trials and Errors, for those of you who've been watching for a number of years, is a unbelievably, among the many programs that we do at the Forum on Law, Culture, and Society, is a very popular one. We've done, this is the trials of our age. So we've done the O.J. case and the Casey Anthony case and the Bernard Goetz case, and we did the Jordan Belfort Wolf of Wall Street case, and we did the NFL concussion case, and what we've done over the year. We even had Larry Flint for the Supreme Court case, the Hustler Penthouse case, it's a Hustler case before the Supreme Court. And so we've done this over the years, and by doing so, we bring together lawyers and journalists and occasionally a very super famous actress. Occasionally that comes, but we've had jury foremen. And so it's really it's a fun, in different program that Folks does. So thank you for joining us. This night was largely inspired by Ali's death. It got us thinking again about Muhammad Ali and who he was, not just as a boxer. And we realized that he was involved in really one of the more interesting, intriguing cases that went before the Supreme Court. Most people don't know anything about it. People know a lot about Ali. They don't know anything about this case that went to the Supreme Court. The man essentially, because he refused induction into the United States military, lost his license, and in doing so, lost over 3 years of his career, his title, and 3 years of his career. I mean, imagine if Tom Brady couldn't play from the age of 25 to 28. In fact, I think that's exactly what the NFL commissioner was looking to achieve. I really think that he was thinking about the Ali case. But imagine what this was, and we'll get Tom Hauser to talk about the impact. It's astonishing to think about. And we have four exceptional people to talk about this. First, on my far right, Thomas Krattenmaker. In your materials, you have a fuller biography. He's incredibly distinguished, three people here, distinguished practitioners of the law. But just for today's purposes, to simplify, Tom was the law clerk to Justice Harlan on the Supreme Court back in the day, in 1970. And he was, and we'll talk about this with some modesty, he may or may not acknowledge this, he might have been directly responsible for Muhammad Ali boxing again, something you'll hear about here today. We have next to him, of course, the lovely Rosie Perez, who many people know from her many movies, my favorite of for which she received an Academy Award nomination and Golden Globe, is from Peter Weir's Fearless. I'm a huge fan of Peter Weir, and that was a great production. That was a great film. But Rosie's also known as the sort of the first lady of boxing. You remember seeing her boxing in Do the Right Thing. And Tom Hauser did a documentary about Ali, and Rosie appears in that. So we have Thomas Crattenmaker, we'll hold the applause until the end, and Rosie Perez. Jonathan Shapiro, to my left right here, Jonathan was Ali's appellate lawyer. So he was the attorney that actually was representing Ali during the period of time that we're talking about. And to his left is Thomas Hauser. Hauser is an interesting guy, also a lawyer, but also a very well-known author of, I think, around 50 books. But he's Ali's principal biographer. In fact, the biography that he wrote about Muhammad Ali was nominated for both the Pulitzer and the National Book Award. And he was also a friend of Ali's, and in fact, they worked on some projects together. And I just want to say something else, which is I'm a huge fan of Kostas Gavras' film Missing. And for those of you who know that film, Tom wrote the book Missing. So that's our panel for tonight, Trials and Errors. So as we know, this, if you've been here before, this goes in a pure conversational format. But let me just give you a quick summary. This is sort of Thane Rosenbaum's Cliff Notes of this very intriguing story and how we got to be here to discuss this. So in 1966, Ali has been the world heavyweight champion for 2 years. 1964, he wins the title from Liston in Miami Beach. If you read my last novel, How Sweet It Is, you would know that. I'm just saying, you would have known that already coming in. But he's at this point in his second year as world heavyweight champion. He becomes eligible for the draft. Around the same time, before then, soon after actually he beats Liston, he changes his name from Cassius Clay to Muhammad Ali. That's why it's Cassius Clay versus the United States. But by this point, he is Muhammad Ali. He says that he has joined the Nation of Islam, and he is now a practicing Muslim, and his name is Muhammad Ali. Because of that, when he's draft eligible, he says that I'm going to seek conscientious objector status under religious grounds. At this point in Kentucky, where he's first inducted, the Department of Justice, which apparently was was somewhat routine, conducted an investigation into the sincerity of Ali. They assigned a state court judge to interview people, family members of Ali, and the judge actually determined that Ali's objections were sincere, that there was not a sham, and they were sincere objections, that he was invoking this conscientious objector status claim. The Department of Justice, however, ignored this recommendation on its own, decided to write a letter to the Kentucky Appeals Board and say, forget that, we're asking you to reject Ali's conscientious objector recommendation. And the Kentucky Board of Appeals did so, and without stating any reasons. They simply rejected his claim of conscientious objector status. Very briefly, there's 3 elements in order to make this claim. You have to actually point to actual religious texts that say you can't fight in a war. You have to be sincere in those beliefs. And lastly, though your claim cannot be selective. It has to be, it must be categorical. And what that means is that you have to say that I wouldn't fight in any war, in any form, in any manner. You can't selectively say, well, this war I believe in and I can fight, but another war I wouldn't fight. And so this third element becomes a key point here. The New York Athletic Commission strips Ali of his title. He's no longer the heavyweight champion. Boxing commissions all over the country strip him of his title. His passport is taken away, so he can't even fight anywhere. At that point, a grand jury brings down an indictment for draft evasion. This case takes place in the Fifth Circuit. The trial goes quick. The jury verdict goes even quicker. It's a 20-minute deliberation. The jury convicts Ali of draft evasion, sentencing him to 5 years in prison, a $1,000 fine. Can we show that first photograph? We have access to that first photograph? Who's here for that? No one's handling it. There was a photograph for this. Aaron, is someone around here? Yeah, find out what's going on with that. 5 years in prison, a $10,000 fine. He appeals to the Fifth Circuit. We're going to talk to his appellate lawyer to see how much he was involved in that. The Fifth Circuit affirms the jury verdict. The Supreme Court denies certiorari. For those who are not lawyers, you don't have an automatic right appeal to the Supreme Court. The Supreme Court has to grant you certiorari so that you can bring it up. Supreme Court doesn't want to hear it. And so that's it. The case is essentially over, except for one incredibly intriguing thing, which is that the FBI, the DOJ, acknowledges that there has been wiretapping in this case. And this is during the mid-1960s, during the Warren Court, when there were far more Fourth Amendment protections on evidence gathering. And so to make sure that because of the wiretapping, to make sure that this case wasn't contaminated by the wiretapping, Supreme Court sends the case all the way back. It turns out the wiretapping was of Martin Luther King and Elijah Muhammad. They did not wiretap Ali. There's some conversations of Ali. The lower court says that there was that the wiretapping has no bearing on the conviction. The Fifth Circuit affirms, and we're back to the Supreme Court. Except this time, the Supreme Court grants certiorari and says it's willing to hear the case. We'll talk a little about why that happened. Meanwhile, Ali's lawyers sue the New York Athletic Commission in civil court basically saying, look, you've deprived me of a number of objections, but they ultimately prevail under equal protection. Why? Because the New York Athletic Commission could suspend you of your license if your activities somehow were detrimental to boxing. Remember, this happened with Pete Rose too, right? The language, detrimental to the sport, seems to be the defining language. So they determined that Ali's draft evasion and the conviction is detrimental to boxing. It turns out, however, hundreds of boxers who've done way worse than Ali, engaged in all kinds of moral turpitude, all kinds of violations of military orders, have done worse things, and they were able to box. And so Ali wins that civil case, and the court essentially enjoins the New York Athletic Commission from preventing from Ali to box. So here we are in year 3. He hasn't boxed. He finally has a new chance. He has a new license to box, but this criminal case is still hanging over his head, right? He has the right to box, but he could end up going to jail for 5 years, right? So this is the intrigue. It's an amazing story. This is all happening at the same time. Meanwhile, 2 months before the Supreme Court granted certiorari, where are we positioned? What's this behind me? Where's Madison Square Garden from here? It's just there, I think. It's just there, a half a mile away. It's just here. 46 years ago last week, to give you a sense of the history, 46 years ago on March 6 was the fight of the century, Ali and Frazier, right? This was the ultimate comeback. I think that there were 2 earlier fights that he had. And Ali loses and gets knocked down in the final round. He had never been knocked down. And Frazier wins that fight 46 years ago, last week, down the block. 6 weeks later, the Supreme Court hears oral argument. So you can imagine, and I want to have Tom talk a little about this, how punched out Ali was at this point, right? He hadn't boxed in over 3 years. He finally gets his license. He's got a Supreme Court case that finally is going to be heard, and he's got a 5-year sentence against him hanging over his head, and a $10,000 fine. I don't think the fine was the big problem, but the idea that he would go to prison for 5 years. And so that's the drama of this. At the time of the oral argument, Ali's face is probably really puffy from that boxing match. And he has no idea where his future is going to be, and everything is in the hands of the Supreme Court. So, Tom, let me just start with you, because if you can help us understand, because I think it is, it was a long time ago, 46 years ago. It's even longer when the case was first brought against Ali. The country at that time was in favor of the Vietnam War, and they were very much not supporting Ali's stand. Is that correct?
Well, no. By the time the Supreme Court heard the case, the country had started to turn against the war. 1968 was really a turning point, and so people were beginning to feel sympathy for Ali.
But when the first case took place,
initially when he refused induction into the United States Army. And it'll be 50 years this April that he did it, because it was April 1967 that he refused induction. Let's not forget, you're only talking, 22 years from the end of World War II. People still believe, and now you look at the world, and many people see it as divided into, the Islamic world and the rest of the world. Back then, you had the free world and the communist world. And if your country called, you answered the call of duty. You went in the armed forces. So there were quite a few people who condemned Ali.
Including sports writers.
For the simple act of not going in the army. And also, he had joined the Nation of Islam, which Arthur Ashe referred to as a sort of American apartheid, which was a separatist religion that ran completely opposite to the prevailing integrationist view of the times. So he was unpopular in many circles, not just with the establishment, but in portions of even the liberal community.
And I read that even the sports writers rejected him.
Sports writers tend to be fairly old-fashioned, but it was really his refusal to go into the United States Army that helped him bond with the liberal community, and then was the platform for what came afterwards.
So that's right. So in a way, that's what actually brings him into the protest movement, and I want to talk to Rosie about that in a moment. But first, let's talk to Tom Krattenmaker, because I'm wondering whether you know, I know that you clerked for Harlan, and you did not clerk for Brennan, but why, if Brennan had not encouraged the court to grant certiorari, this thing would have been over. We wouldn't even be here. We wouldn't even know who Ali was. His career would have been over. What can we speculate why Brennan said, after not wanting to hear the case the first time, why he wanted to hear the case the second time?
If you tried to make a list of all the things that started off against Ali and then went for him, in this case, we would be here all afternoon. This is one of them. There are just dozens. The image I always have, because he was a boxer, is of a guy who keeps getting punched and punched and punched, and he's down on the canvas, and the 7, 8, 9, wait a minute.
He's
Did
up.
we dot the I and cross the T on that? Let's hold off a minute. Boom, he's down again, 7, 8, 9. And he just keeps crawling up off the canvas. Half of these things nobody knows about, like the first time when they sent the case down. Nobody knows for sure why the court granted certiorari in January of 1971, but we do know that only 4 justices voted to grant. The 4th was Justice Black. Goodness knows why Justice Black did it, probably out of a courtesy to Brennan. And my understanding is that Brennan argued very strongly that the people wouldn't understand if a person who had the public visibility of Muhammad Ali couldn't get a hearing in the Supreme Court. And he sort of pushed that. And I don't know whether anybody else agreed. I think Stewart and Douglas went ahead, voted to grant because they thought Ali was entitled to prevail. But in any event, Brennan managed to get his 4 votes. As if you've seen the HBO show, you can see Justice Brennan saying, all I need is 4. It's just about 4. And that was it. But at that time, that would have suggested that he was going to lose the case, even though they granted cert, because you need 5 votes to win it.
Well, okay, so let's talk a little about what happened after oral argument, because there were 5 justices that would have voted to affirm the conviction, and therefore, again, we wouldn't be here. Ali would have been in jail. It was 5. The initial conference of the judges after oral argument was 5-3, right? It was Berger, Black, Blackman, White, and Harlan, your former boss, affirming, and then Douglas, Brennan, and Stewart on the other side. The one thing I thought we might talk a little about is the oral argument itself, which is actually really interesting, especially when you think a little about today's times. The Solicitor General made the point, remember I said one of the elements, the last element, is that it can't be selective, that you have to be opposed to all wars. You can't just pick and choose the wars. And so they basically said, look, he said that Ali said he would refuse to fight war on the side of the white people. And that's what the Solicitor General made the argument, saying he's saying he would fight for Allah in any holy war under jihad, but he refuses to fight for any war on the side of white people. That seemed to be the argument by the government. And that's the classic example of selective. This actually came up with respect to the Vietnam War, where Catholics took a position, a moral position, that they didn't want to fight in the Vietnam War. They thought it was an unjust war. And that argument didn't work because they were just saying, no, this is the war I don't like. I might like another war, but this war I specifically don't like. What do we know about, let's talk to Jonathan, about that oral argument? I mean, how did you think it went that day? Did you think that you would get more than 5? Did you think, were there any justices in particular that you thought were on the fence?
Well, at the time, I was a 30-year-old lawyer at the NAACP Legal Defense Fund in New York. I was sitting beside Chauncey Eskridge, who was Ali's personal lawyer. And, of course, I had worked on the case for months. We were completely convinced that we were right. The issues were, we thought, clear-cut as can be. There were 3 grounds that a person had to establish in order to get a conscientious objector exemption. He had to be opposed to war in all form, based on religious training and belief, and sincere. And of course, the Justice Department had rejected all of those grounds and said that it wasn't based on religious training and belief. It was based on the political and racial views of the applicant. It said that he would fight in a war. Of course, the war that he had agreed that he would fight in was the same kind of theocratic war that Jehovah's Witnesses had always said that they would fight in, and the Supreme Court years earlier had said a theocratic war is not a real war. And of course, finally, the Justice Department said he wasn't sincere, but there was a Kentucky judge who had heard all the evidence and said he was sincere. What better argument could there have been?
Now, but the oral argument itself...
The oral argument itself, Erwin Griswold, my dean from law school, argued for the government. He was a brilliant and very fine advocate, and he was able to make the case, as Thane mentions, that this was a selective views on war. He only was opposed to fighting for the white man, but that really was so disingenuous. And but nevertheless, it clearly hit a chord among the justices of the court. They had just recently affirmed convictions of two applicants who had said that they were opposed to this war because it was an unjust war. So selective opposition was a real hot issue. And frankly, at the end of the argument, I was not happy.
Okay. Rosie, let's move this to a different topic. Maybe you can help us, because this is something you've given a lot of thought to, of what Ali meant in the broader culture. As a man, as an athlete, as a man of color, as a religious figure, how did people of color respond to him differently, perhaps, in this trial? I mean, this, in fact, may have sort of been, you could almost make the argument during the social upheavals of the 1960s that this case represented so many of those racial divisions.
Right. It was an age issue amongst people of color, because the younger people were saying, "Say it loud, I'm black and I'm proud," and the other people were saying, you know, Martin Luther King has made so much progress for us. Let's not lose that.
So you're saying Ali was identified with the more radical Black Power movement?
Yeah, but also he also identified with the young white radicals of America at the time too. When he, when he was going, college kids were flocking all around him. And I remember my older cousins always talking about him, and I was telling Thomas this, that Ali gave them license to have a certain audacity that they didn't feel that they were allowed to have. For him to stand up in front of a camera and scream in the ring, "I'm a bad, bad man," without any apology, that was just extraordinary. And then to stand up in court as well for his beliefs, and every time there was a camera on him, he never backed down. That was extraordinary as well. And so,
and we hadn't seen that in a black athlete either. Or
we did. We had Jim Brown and
roughly the same time period.
Around the same time period, but it wasn't as pronounced as what Ali was offering everyone. And his audacity allowed my generation to be even more obnoxious, because that's our right, we are the fruit of his labor, and it was really impactful, but it was also a very, very confusing time for people of color because, as you say, during that time, he was preparing for the Frazier fight. And here's this man, standing up for black people in America and colored people in America, and then he's calling Joe Frazier an ugly black gorilla. And it was very confusing because as a person of color, that hurts. Because even if you're light-skinned or dark-skinned, there's someone whiter than you. So you calling another person of color a black gorilla and literally having a gorilla doll and beating it, it was very, very confusing. It was very confusing. So he was great, but he was very controversial.
In his own man. I never heard that, Tom. I don't know if you had the interesting idea that maybe Abby Hoffman, Jerry Rubin were watching some of the theatrics and saying, hey, this is really how you get attention. If you want to lead a protest movement, follow Ali.
Well, let's look at why Ali mattered. I mean, first, he was arguably the greatest fighter of all time. Second, every time he looked in the mirror and said, I'm so pretty, what he was really saying before it became fashionable was black is beautiful.
That's right.
Third, when he refused induction into the United States Army, he was seen as standing up for the principle that unless you have a very good reason for killing people, war is wrong. Now, Ali was not a saint, and initially, when he was told that he'd been reclassified as 1A, eligible for the draft, and uttered his immortal phrase, I ain't got no quarrel with them Viet Cong, that wasn't as much a religious statement, a statement of principle, as it was, this was a 24-year-old guy who thought he'd put the Army behind him. He'd been reclassified as unavailable for military service because he'd flunked the Army intelligence test. Then they lower the standards across the board because they need more manpower. And all of a sudden, his life is going to be turned upside down. But to think that Ali was some sort of deep political thinker, I mean, to give you an idea of his grasp of geopolitics, Jerry Eisenberg, who might be the best sports writer who ever lived, tells the story of being with Ali in London during that time frame, and the people in London loved him. They were gathering around, hugging, kissing, asking for autographs. You didn't have selfies in that day. And Ali looked at Jerry and said, these people in England are so nice. I'll bet in their whole history they never had a war.
Speaking of politics, one last question.
May I add something?
Yeah, yes.
Because you
Rosie.
said about the sports writers. I just want to add that there were sports writers, a few that did stick up for him, and sports commentators, and one of them was one of my favorites was Howard Cosell. He stuck his neck out for him.
He never abandoned him.
Never abandoned him, and Larry Merchant, right? Larry Merchant, too.
I think
And Sam Lipsyte, I think, also.
John Lipsyte and
John
Jerry
Lipsyte.
Eisenberg. Larry sort of straddled it. There was a period of
Well, that's not what he told me.
4 or 5 years. And I think Larry is great. Larry is a good friend. Larry and I talk on the phone once a week. But there was a period, when people were refusing to call him Muhammad Ali, and it would drive Bob Lipsyte nuts because he'd write an article for the New York Times and use Muhammad Ali, and then a copy editor would change it to Cassius Clay. And Larry's way of finessing that was in his columns, he would call him Ali Baby.
One last comment that maybe one of you can respond to this. I read somewhere that Lyndon Johnson was somewhat involved in the DOJ's ignoring the judge's opinion that they assigned for the preliminary investigation, that Johnson thought that he was a bad man and did not want to see this man avoid the draft. Do we know anything about that?
Well, I think that there was there was a lot of talk about both Johnson and Mendel Rivers, who was the head of the Armed Services Committee, who were dead set against letting Ali off the hook.
Now, is that
they wanted him in the Army.
Did they want him on combat duty? Because let's just remember for a second, Elvis Presley didn't serve in the front lines.
I think everybody accepted the notion that if he had gone into the service, he would have boxed. He would have done demonstrations all over the country. And that, of course, was one of the reasons he was as sincere as he was, because he didn't have to fight. It wasn't a question of cowardice.
He wasn't worried about dying.
He could have fought throughout his time in the service, and he wouldn't have lost anything. That was a real mark of his true sincerity.
Well, but let's, when you say he wasn't worried about dying, he might not have been worried about dying in Vietnam, but Malcolm X had been assassinated after he split with Elijah Muhammad. And there's a growing body of research in recent years that really began with Dave Kindred's very fine book, Sound and Fury, and recently came full circle with Randy Roberts' book about the relationship between Ali and Malcolm X, that make it very clear that Ali was afraid that if he broke with Elijah Muhammad, they could be very severe circumstances.
Tom, let's go back to you, because I think now let's go back to the Supreme Court case. The justices vote 5-3. Oh, remember, there are 9 Supreme Court justices, so you might wonder what happened to the 9th. Thurgood Marshall recused himself. He wasn't involved in this case at all because he had served as a Solicitor General in some of the earlier cases dealing with, as the case worked its way up the Supreme Court. So we were only going to have 8 justices on this. So it's 5-3. At that point, Ali's finished, right? It's 5-3. They were affirming the conviction, and that's what the public did not know, that it was that close to ending Ali's career. At that point, Justice Berger assigns the opinion writing for the majority to your boss, Justice Harlan. And your boss turns to you and says, I want you to take a crack at the opinion. And it's interesting, I read somewhere, I don't know if this is true, which is interesting if you're a lawyer. At the time, you were working on Cohen versus California. Did I get this right?
True.
So he was, do you remember this is the case, the First Amendment case, fuck the draft, right? So Tom was already working on the fuck the draft case, and he's now working on Ali saying fuck the draft. That's all you did for a while. Your whole life is marked by the social upheavals and the draft. So
it was a way to make a living, what can I say?
So the justice turns to you, and something bothered you about this case, because Justice Harlan at that point was not, and I didn't hear from Jonathan whether Jonathan thought that in the oral argument Harlan could have been convinced. And maybe we'll come back to that. I don't know if you looked at the 8 justices and said, I lost these crew, but I think I might get him. Harlan was not sympathetic, but just tell us briefly what happened. It didn't sit well with you. You went back to Justice Harlan and you changed his mind.
Something like that happened, yeah. The principal responsibility for the case was another law clerk in the office, and if we're handing out credit, that's really where the credit should go. But the way things were done there, we were always encouraged, not only free, but encouraged by the justice to kibitz on all the cases. And I thought I knew something about this case, and it stemmed from having read the Message to the Black Man in America and from having read the autobiography of Malcolm X.
Now, can you explain what that is? Because I want to talk a little about that. It's not like you went back and read the Quran. You read something else. What was the significance of this? Was it a pamphlet by Elijah Muhammad?
Because Elijah Muhammad was not preaching the Quran. Elijah Muhammad, Tom, the other Tom could probably tell you better, or Jonathan could. I don't know how much you want to get into this. The reason Justice Douglas screwed up the whole case
because he brought the Quran
about the Islamic
because he brought the Quran back, right?
What Farrakhan was preaching was an Americanized, Black American version of Islam. So, for example, had Farrakhan been preaching the legitimacy of jihad, I don't know that that Jonathan Shapiro would have had a leg to stand on, because then it certainly would have been the case that certain wars, real wars, are okay under that
So when
view.
you read Message to a Black Man in America, what did you discover?
By reading that and by reading the autobiography of Malcolm X, I thought I could understand that, to try to make it very simple, what we had was a lot of rhetoric surrounding a very simple proposition, which is we are pacifists. We do not get involved in real shooting wars on behalf of anybody. This is not, now, of course, if Allah.
But there was a language
war,
also that said
well,
Islam is the religion of peace. That was also stated.
Well, that is true. Ali said that. I'm not so sure he said that in 1971 as opposed to after the World Trade Center. But I thought what Rosie said was so profound. This is the way people heard what Ali was saying, and particularly young people. But there was also a legal case here. And Harlan was not a young person looking to be radicalized. He was a lawyer's lawyer and a judge's judge. And it's said in there, you already said this, Thane, that you've got to be opposed to participation in all wars. And the Supreme Court earlier that term had said, if your religious belief leads you to oppose some wars but not others, sorry, you're not a CO under that statute. That came up in, I think Thane mentioned, there's a strand in certain Catholic doctrine of a just war. Think back to the Crusades. And some people argued that they were raised in a Catholic tradition where the Vietnam War was unjust. And the Supreme Court said, well, would you have thought World War II was unjust? They said, oh, no. And they said, well, then you're not a CO. So this case was all about...
conscientious objector.
Conscientious objector. This case was all about, legally, whether he was a selective conscientious objector, that is, he just opposed the Vietnam War, or he just opposed wars that weren't being fought for Muslims, or he just opposed wars that were being fought for the United States of America, or he just opposed wars that were being fought for white people, and he made statements that could be construed that way. Each of those, I've defined these statements, and the Justice Department, I quoted them all here in the brief. So what Harlan had to confront was he looks at these statements, he says, well, of course he's not opposed to all war. And as Jonathan explained, that's basically what former Dean Griswold argued at the oral argument.
He admitted, I would fight for Allah, but I wouldn't fight for white people.
He said in his brief that the petitioner himself stated, and these are direct quotes, he is not to participate in wars on the side of on the side of non-believers. This is a Christian country and this is not a Muslim country. The Muslims don't go to war unless declared by Allah himself or unless it's an Islamic world war or a holy war. The Muslims are taught to defend themselves when we are attacked. And those Viet Cong are not attacking me. Why should we Muslims get involved? And all the Solicitor General had to do was read those. And I suppose what I was trying to do was to talk to the Justice about understanding those statements in context, understanding that they're not made by somebody who's a professional dogma writer in the Vatican, but is a 24-year-old boxer who maybe went to high school, but certainly doesn't have a PhD in theology, and that what he was trying to say was exactly what Jehovah's Witnesses had said during the Korean War. I thought I had precedent on my side. During the Korean War, the Justice Department prosecuted someone for failing to submit to induction because he said that I would fight a war if Jehovah declared it. And the Supreme Court, almost unanimously, I think there was only one dissent, said that doesn't mean he's not a conscientious objector. When they say opposed to participation in all wars, they mean all real wars with real bullets, real shooting, run by real men. They wouldn't have said
but
women.
that's an interesting question, because what essentially happens is that you and Justice Harlan basically say, well, jihad is not a serious thing. It's an abstract thing. It's a hypothetical.
With jihad, I don't mean to be pedantic with you. Elijah Muhammad wasn't talking about jihad. He didn't say that. If jihad had been here, it would have been a wholly different case.
Did he say holy war?
Yes.
Okay, so, but again, the concept of the holy war was to say, in the Jehovah's Witness, I think the Ciccarella case, I think the court says, look, there's no evidence that Jehovah ever commanded anybody.
Oh, yes, right, exactly.
Right. They never. There's no evidence, or for that matter, is there any evidence that Jehovah plans to?
Right, nor is there any evidence that Allah ever called
Right,
for
and so that they
so.
dismiss this
Right.
as some joke.
And that's exactly
this is a joke. This is this is a religious joke, but it's not ultimately real.
And that was the brunt of what I was suggesting, and I think it's very much like, and I'll let Jonathan talk to this, what Jonathan had argued in his brief, and I know that's why he felt confident about it. So what I said, I think what Rosie said was so profound. To some extent, I felt like, here's somebody, I think, I'm 27 years old at the time. I've spent my law school years in New York City. It's where I read this stuff. And here's Justice Harlan, who is one of the most wonderful people I ever met, but next to the word patrician in the dictionary is a picture of John Marshall Harlan. His grandfather was a Supreme Court justice. He took his law degree at Oxford University. Every day he came to work with his Phi Beta Kappa pinned across his vest and his three-piece suit that he'd earned at Princeton. And he was, at the time, I blush to say it, almost as old as I am now. So he was generations. And I think what we were trying to do was to, so I'm coming back to what Rosie said again, it's trying to get the message to another generation that what Ali was doing was talking a kind of an incendiary rhetoric, but he was trying to say what you said, Thane, and what he said later on, Islam is a religion of
So
peace.
when you hear that, Jonathan, I'm just curious, did you make that argument in oral argument or in the brief? Because here's what I hear when I hear that. I think that it somehow essentially degrades, devalues, dismisses the religious convictions of your client to say, oh, you know, those silly religions, they always talk about the whole whatever, and those things never happen, and so because they don't happen, we don't take them seriously. I mean, the reality is he's saying, I would fight that war, but I wouldn't fight this war. And we've gone to the trouble to just go, I know, but that war would never happen, so it's ridiculous to even talk about it. Was this an argument that you made?
One of the issues in any kind of a conscientious objector case is that it's the views of the registrant, of the applicant, that matter, not necessarily the views of the religion. And what the government did in this case was to cherry pick the statements of Elijah Muhammad, to cherry pick statements by some of the co-religionists, which made it sound as if the religion was one of violence, of jihad, whereas what was the focus and should be the focus was Ali's views, and Ali was very articulate in expressing his views to the Kentucky judge who heard the case, persuading that judge that he was sincere in his opposition to war in all forms. So what the government did was to try to really focus the court on the views of the religion and neglected Ali's own statements, which were very, very strong and sincere.
Let me clarify this if I can, and that is a lot of this discussion was relevant to the decision as to whether or not to grant the petition for certiorari. But my understanding is when the case finally got to the Supreme Court, the judges initially voted 4-4, which meant the lower court conviction would have been affirmed.
No, they originally voted 5-3,
No,
and
that's
then
right, 5-3,
they
and
went
then
4-4 because of
4-4.
Tom.
Okay, but
Tom
then
and friends.
what happened was the final decision was based on a very narrow
Right, we'll talk about
procedure technicality, and that was that.
But it wouldn't have started. None of this would have happened had they not come up with this other argument, right, Tom? Like, they would have never gotten to that technical side.
That got them to the point where cert was granted.
If anything, it just confused the court, right? I mean, it just seems to me that it got them to rethink what does it mean to have selective participation? What does that mean?
But if this case had been decided on the merits, it would have been a 4-4 split, and Ali would have been in jail.
Because 4-4 split would have ultimately affirmed the lower court conviction, and not only that, he would not only have been in jail, but there would have been no opinion. There would have been no written opinion, so no one would have even known why. Right? Which is even worse.
That's true. Why don't I just jump in and clarify a couple things? The vote was 5-3. The opinion was assigned to Justice Harlan. Everybody assumed he was going to write an opinion affirming the conviction. The other 4 who had voted that way would join the justice's opinion. Stewart, Douglas, and Brennan would dissent, and Ali it would be affirmed, and he would go to jail.
And you were given the assignment to just write that opinion.
And my co-clerk. And
right.
in any event, what occurred after the stuff inside the chambers is that Harlan sent a memorandum to the conference saying, I've changed my mind. I believe that he is, in fact, sincerely opposed to fighting in all wars, and that a proper standard of judicial review enables us to substitute our judgment for that of the draft board. And I think, yeah, I blush. Do I blush to say this? No, I'm too old to do that anymore. I think it's a perfectly brilliant opinion, and it's never been published. And I have a copy of it, and if you're an editor and you would like me to write a book about it, bring me the contract.
I would like to see that opinion.
Now, the reason it never got published is that there's this wonderful, beautiful opinion that gets carried around to all the chambers, and sometimes we'll talk about how all that's done, and I'm sitting there waiting for everybody to say, huzzah, hurrah, hooray, this is the best thing since Marbury against Madison. And what happened is that Stewart, Douglas, and Brennan immediately said, I'm going to join that opinion, and then the silence was deafening. Nobody else did. And one can speculate why that was the case. Warren Burger told one of his clerks after reading the opinion that John Harlan has become an apologist for the black Muslims. And whatever Justice Burger believed...
You mean the Oxford guy?
Yeah, exactly. Yeah,
the Oxford guy, the most likely candidate.
Right,
for that.
And of course at that time, whatever the Chief Justice believed, Harry Blackmun believed. They were the Minnesota Twins back then, so he always cast 2 votes. And so it was sitting there, and then as Tom said, that would mean that if nothing happens, it's 4-4. That means not only is the opinion below affirmed, because there are not enough votes to overturn it, but no opinion would be produced by the Supreme Court. Justice Stewart then said 2 things. He said, 1, I want to find precedent for finding that we can write an opinion even when the court's equally divided, because I believe that the people still voting to affirm this conviction are hiding behind the fact that they don't have to write an opinion. I thought that was an interesting statement. I mean, Stewart said to his law clerks, I think if they were forced to write an opinion as to why they would affirm this conviction, they couldn't do it in light of what Harlan has just written. But another thing Stewart said is, I think, back to what Tom's point is, we might be able to dispose of this on narrower, what I'll just call procedural grounds, that there was sort of an oversight when I talked about not dotting all the I's or crossing the T's, that the draft board didn't dot an I, and we could get behind that. And so Stewart wrote a little opinion. In fact, I keep saying it's a Stewart opinion. If you look in the books, it says per curiam. It was written by Mr. Justice per curiam. And everybody on the court started to agree with it, except...
Even though it was inelegant, dramatic.
It was inelegant. And
didn't say anything.
I don't know if Jonathan has an opinion about this. When the court granted certiorari, they limited the grant. They said, we're only going to discuss the issue of whether he was a selective CO. So technically what Stewart wrote was completely outside the grant of certiorari, although, to Jonathan's credit, he briefed that issue anyway. He didn't let himself be deterred by the limited grant, so that the work had been done for Stewart.
The program code is TRI 031617. The program code is TRI 031617.
So there was a legal basis upon which to say that the Kentucky Appeals Court didn't state any reasons for the denial.
A legal basis that I regard as fairly flimsy.
One thing that
I don't like it. I mean, I don't even understand. It seems to me
I don't know why they had to give a reason.
It was so anti. It just seems like not even an answer. So
one thing that's important here is that after Harlan was persuaded, by Tom, who was then persuaded by my brief. But in any case,
You see what's going on here.
once Harlan was persuaded, and Harlan was an important figure on the court and carried a lot of weight. And the only issue that the government was raising on the appeal was that Ali had a selective opposition to war.
Right.
And if the court decided that it wasn't a selective opposition to war, what I think many of the justices were afraid of was that the court would be endorsing black Muslims as conscientious objectors, and where would we get the people to fight in Vietnam? Because the war was being fought on the backs of black people, many of whom were black Muslims. And I think the court was really concerned that if they adopted a view which gave black Muslims as a religion a basis for making a conscientious objector claim, there would be a real problem in raising the people to fight the war.
Because everyone would then invoke the same.
I think that's why,
That's
to a
a
large
view that you
extent,
can't ascribe to Douglas, Stewart, Harlan, or Brennan, because they all voted to reverse the conviction.
that's why.
But I think Jonathan's
Stewart's
right about the
opinion,
other four.
which found a way to affirm to reverse the conviction on a technical ground that didn't create any precedent. A per curiam opinion like that does really not create precedent. It didn't affirm any principle. It simply said that the draft board did not decide which ground it was denying the exemption on the basis of, and the government had already admitted that two of the grounds that the Department of Justice had argued to the draft board, had submitted to the draft board, that Ali was not based on religious training and belief, and that he was not sincere, those were in error. So not having given a reason as to why they were deciding, there was no way to know whether the draft board had based its decision to deny the exemption on an erroneous ground or on the one ground that was in contention, that is, the selectivity of his views, and that's why the court reversed the conviction.
Rosie, I want to come back to you. Last week, the forum, one of our earlier events last week was in connection with a show that's going to be premiering next week, Shots Fired on Fox. So we did a night devoted to Shots Fired. We had the cast and some of the showrunners, the producers. So these last several weeks for the Forum on Law, Culture, and Society, as you can see, has really been very much deeply entrenched in the world of racial injustice. When you think of the Black Lives Matter movement today, do you think that there's a line that we can draw from this case that empowers the black?
Absolutely. Absolutely.
Go closer to the mic. Yeah.
Oh, sorry. I truly believe that Muhammad Ali.
Wait, I don't think you're on.
Oh, I'm sorry.
There you go. Go ahead.
Okay, there we go. It's the first time I've been told I wasn't been able to hear someone hear me. I truly believe that it wasn't just Malcolm X. It wasn't just Martin Luther King. I think that Muhammad Ali was the everyday man. He wasn't well-educated. He was he was a celebrity. He wasn't a scholar. He wasn't leading a charge. He just said, this is wrong and I don't want to do it. And as an American, I have that right. And this is a Black American saying that. So he gave birth to a new type of activism in America for people of color, to have an individual activist spirit, that you didn't have to be scholarly, you didn't have to be revered, you just had to have a belief and a conviction to stand behind. And that is exactly what Black Lives Matter is all about. It was just a bunch of kids screaming, this isn't right. You know, hands up, don't shoot, this isn't right. And I don't think that, in my personal opinion, that Black Lives Matter was intentional. It just happened. And I think that's exactly what happened in the case with Muhammad Ali. It wasn't intentional. Just when Thomas and I were talking about when he first heard that he was going to be drafted and how stunned he was. You know, he didn't want to, rush up the hill with a charge. He was just like, I don't want to go. I mean, seriously, it's just like, I don't want to go. And it's the same thing as like, I don't want to be shot because of the color of my skin. This is wrong.
But one of the things we heard today, which I hadn't thought about, but it sounds right, is that Ali probably knew that he wouldn't face the front lines. He might have this other problem about being assassinated. But, athletes historically have movie stars, athletes, they go away. Joe DiMaggio, they come back heroes, right? I mean, here was a guy that really, this was a real consequence to do what he did. He could have ingratiated himself to white America, right? I mean,
Well,
in fact, I
Presley-
think that happened with Joe Louis, right?
Yeah.
Joe Louis went to World War II, and he ingratiated himself with white America.
Yeah, but Sugar Ray Robinson was a draft dodger.
Right.
Is that right?
Yeah, oh yeah.
Yes, he was. And Elvis Presley was reluctant because he didn't want to shave his hair. It's true. But it sounds stupid, but it's true. He wasn't the first. But my point is,
But he
that
had
he
the
gave,
worst to lose, though.
Yes. But he gave voice to the individual, because even with me as a young kid growing up watching Muhammad Ali, I felt like I could stick my chest out, and I had that right.
And you don't think he was saying it as a message it's like the message to black man of America that Thomas was referring to from Elijah Muhammad. You're saying that it may have been more personal to some degree for
I think
Ali.
initially it started out personal, and then it grew into a movement, and that he got behind or in front of, and that's what I'm saying, and it's a special thing because people of color in America were always hesitant to step out, and there was only a select few, but here's the everyday guy who was willing to do it.
So we're going to take some questions from the audience in a few minutes, but there's two things that I'm still interested. One is the very unsatisfying end that we've talked about, that this decision was ultimately decided on some technical error, hence trials and error. Oftentimes we focus on the error, and it's not as dramatic. It doesn't make for a great TV, but in the end, there were reasons why the court, we came up with some reasons why the court thought, let's do it in the most narrow technical way, which if you went to law school, this is what we do. We find the most narrow technical decision instead of the most, dramatic affirmative one. But it is, I would say, unsatisfying. If we didn't convene this trials and error, most people wouldn't even know that these other legal issues were in there, right? Because instead you got this per curiam opinion that's just so flat in every way and so unexciting in every way, when in fact the Supreme Court, it was very exciting what was going on at that time. These were white men, remember Marshall was not involved in this discussion, of a certain age, trying to make sense of a black man who was just joined the Nation of Islam. It was an inconceivable, and reminds me a little, we've had Sonia Sotomayor as a guest here twice. For those of you who've seen her here twice. And one of the things that I think her appointment to the Supreme Court represented was this idea of the people's judge. That here was a woman, here was a Hispanic woman, a Latina, here was a woman who grew up in the projects in the Bronx, And there were people when President Obama nominated her and said, you know, she's a woman who has a compelling life story. You know, many people, law professors, were very upset. That has nothing to do with this. This is supposed to be about judicial temperament. But I think what we're learning, no, it has a lot to do with it, because these 8 men had very little capacity to understand anything about Ali. And one would hope that we're living in a very different time. Let me just ask one question for all of you. If the argument was being made today, and we didn't have Message to a Black Man of America, but instead we had the Quran, right? I mean, this is, you know, the argument that you made earlier, Tom, about, well, you know, these things are hypothetical, they're abstractions. They don't seem like abstractions today. Justice Douglas thought that this was really a First Amendment free exercise case, right? That you should be able to exercise the freedom of religion. And he thought that even Catholics who opposed Vietnam should also be able to rely on that. But I'm saying this today is an enormously different case because jihad and holy war is being invoked by certain elements, radical elements. It may or may not be representing the actual language or theology of Islam, but they're using the words. They're not abstractions.
Well, if you want me to start, I get asked that a lot, and the short answer is we don't have a draft anymore, and we don't have a conscientious objector statute, and this was a statutory interpretation case, not a constitutional case. If you want to know, if we had a war and we instituted a draft, and Congress, what do you want to say, saying they did put in a conscientious objector statute or they didn't?
That they put in a conscientious objector statute.
Well, then it would depend on how they wrote the statute.
Spoken like a Supreme Court law clerk.
And if they don't write a statute, then it depends on what you find in the First Amendment. And so far, only one justice would have found a right not to participate in a war that you don't like because it violates your scruples. That only one person said that, and that's Justice Douglas.
He was the only one of the...
No, because it's very hard to run a society if people get to decide whether they're going to obey laws about tax or environmental pollution or going to war all by themselves.
Yeah, and
very, very hard.
The law is what the court says it is. I mean, the Berger court would not have found that there was a right to gay marriage. Unfortunately, we might be sliding towards a situation where Kim Davis's freedom of religion is seen as giving her the right to deny marriage licenses to gay couples. And then you get to the question, well, what if your religion says you shouldn't give marriage licenses to interracial couples? But it's what the court says it is, as we've learned over the ages.
Jonathan, so, I mean, I want maybe you and Tom to just briefly talk about your relationship with Ali. What was his mood like during that 3-year period? Did he think he would prevail, or did he think it was rigged?
Well, I think you may have gathered from some of the other remarks that Ali was not very much involved in the actual litigation.
So he didn't read the briefs?
If he did, he never told me about it. But I was at the NAACP Legal Defense Fund, which was right uptown in Columbus Circle. And when Ali came to the office, it was quite an event. Everybody found a reason to be in the reception area. Everybody was out of their office. And it was really, he was magnetic. And it was just a really wonderful experience. And of course, he was magnanimous about it, and he made an effort to be with the people.
But he showed up to his lawyer's office. Yeah. Did he say, "This is my lawyer, and we're going to win"? Did he talk as brashly as Rosie said about boxing? Did he say, you know, we're going to go to the Supreme Court and we're going to...
I think we told him he was going to win, but I'm not sure how assured we were of that. But the other benefit that we had was right before or while we were working on the cases, he had 2 fights in Madison Square Garden, and we got free tickets.
So you were there for that.
And so I was there for the
May I say,
Bonavina fight.
excuse me, he did feel persecuted, right, because of that famous cover. What was, Tom, that famous cover where he had the arrows coming out of his body?
Esquire magazine.
It was Esquire?
Yeah.
Do you guys remember that?
Yeah, there was that photo. The cover.
Yeah, where he had,
St. Sebastian.
Yeah.
Yeah.
Thane, I might just add one point. There's a wonderful little film clip that's in one of the documentaries, and he's speaking. It's one of his things where he's speaking to college campuses, and he says, "I'm told that I have 2 choices. I can go to jail, or I can go into the Army. I think there's a third possibility, and that is I can get justice."
Tom, unfortunately we had a malfunction with our photos, so I had some photos I wanted everyone to see, but one of those photos was of Ali on Broadway. This guy was trying to earn a living, and so he spoke at universities and colleges around the country, and I love what Rosie said, that he may have animated the protest movement, and given them a whole new sense of technique in theater, which I had never heard. I think that's an incredibly original thought. And you said, you were right, that he was mobbed wherever he went. When he went to universities, everybody treated him like he was in Jonathan's office. But what other things did he do? He was in an off-Broadway or Broadway show that opened and closed very quickly.
Well, he was, at one point in this process, he was in a show on Broadway called Great Buck White. It was a musical. Clive Barnes actually reviewed his performance favorably, said his singing wasn't bad, but the show was.
Was singing?
He sang. You all can go on to YouTube, type in Muhammad Ali balloons, and you will hear Muhammad Ali in the late 1960s singing on Broadway. You can also, if you want something a little jazzier, go in, type in Muhammad Ali, Sam Cooke, and you'll have Muhammad Ali and Sam Cooke singing together. Or he also did a cover version of Stand By Me, although I think Benny King did it better.
All right, let's take a few questions from the audience, and then we'll say goodnight to everyone. It says, here's one. In today's climate, oh, by the way, one other person corrected me. Did I say March 6th? It was March 8th. 46 years ago, because they said this person really knew it was March 8th.
And one other...
Good for you, you caught it.
Yeah, well, no, I didn't. I read it here.
They caught it.
Yeah, somebody said, no, it was March 8th. March 8th.
One other slight correction, which is
Yeah.
Joe Frazier might have been the first person to knock down Muhammad Ali in a professional fight, but Sonny Banks and Henry Cooper did knock down Cassius Clay.
Is that right? But wait, but there's not, that's like a Rocky movie. He didn't also attempt to fight a wrestler during this time, did he?
Well, he did.
He did.
Later
Okay.
on, towards the end, he fought somebody named Antonio Inoki in Japan.
So this
was horrible.
this was a different payday for him. It wasn't because it was.
So that was much later.
Yeah,
That
I wonder,
was in
and of
the
course there would have been no, that was wrestling, that not boxing, and so he could have theoretically done that.
Well, and that was horrible. But this was after the Frazier fight in Manila, and originally it was supposed to be scripted. The idea was Ali would go to Japan, he would fight Inoki, and Ali would be beating him up, and he would turn to the referee, implore the referee to stop it, at which point there would be a sneak Pearl Harbor type attack where Inoki would pin him, setting the way for an even more lucrative rematch. And then a couple of days before the show, Ali decided that his religion would not allow him to participate in fraud. So they did it for real, and it was dreadful. Inoki spent 15 rounds crab walking around the ring on his butt, kicking out, and Ali spent 15 rounds dancing around the ring, trying to avoid getting kicked in the shins. It was horrible.
I'm just you'll know this. What were the purses like in the mid 1960s? What did Ali forfeit? Tens of millions, hundreds of millions?
When Ali fought Joe Frazier the first time at Madison Square Garden,
March 8th,
each fighter was paid $2.5 million, which was unheard of for that point in time.
Wow. 1971,
The time they got to Manila, the purses had gone much higher than that. Ali got $6 million. When he fought George Foreman in Zaire, Foreman got $5 million, Ali got $5.45 million. But prior to that, prior to Ali Frazier, if a fighter's purse was $400,000 or $500,000, he was doing very well.
So when he knocked
The
down
exception being Jack
Liston in
Dempsey.
Miami Beach in '64, it was under $1 million.
Oh, yeah, it was probably about, I'm going to guess, $250 for Liston, maybe $150 for Ali. Jack Dempsey and Gene Tunney each got $1 million when they fought each other, but that was a different era.
But I mean, it goes really to Rosie's point, and this idea that on principle, I mean, what he gave up was, this was not pocket change. This was huge purses. And the goodwill of showing up in a military uniform, and said he just wasn't going to do either of it. Here's from the audience. In today's climate, do you think Ali's words about Islam would have been given due consideration? In other words, because that's actually an interesting point, right, Tom? That goes back to your point. He's saying, I know now everybody knows about the Quran, before only Douglas did. So everyone knows about the Quran now, but I'm still referring to something else. I'm not referring to the Quran. When I say holy war, I'm talking about something else. This is an interesting question, whether he would have been able to say, I know you think I'm talking about what ISIS is talking about, but I'm not talking about what I'm talking about what Elijah Muhammad is saying.
If LeBron James said, I ain't got no quarrel with ISIS, he would lose most of his commercial endorsements, for starters.
Because that was the original thing. He says, I have no quarrel with the Viet Cong. They never called me, what did he say?
Well, he didn't say. One of the things that's been misreported over the years is he's also been, they've said, Ali said, no Viet Cong ever called me nigger. And in point of fact, that was Stokely Carmichael who said it.
But,
Ali
that
did
was one
not
of the
say it.
slides I was going to show you, so I'm glad I didn't show it to you, because that would have been false, and Ali wouldn't have liked that.
I have yet to see a contemporaneous quote of Ali saying that. What he did say was, I ain't got no quarrel with them Viet Cong.
It's interesting you say that, because with Cat Stevens, who, I don't know his new name, but Youssef, like, he backed away, by coming out in the public as,
You're saying his career ended, or he pulled away from his career as a Muslim?
No, when the tensions in the Middle East started to begin.
Oh, you mean right
now? Currently,
now.
yeah, during Bush, and he came out and he was speaking up for Islam. There was a huge backlash.
Really?
Yeah, and then he kind of just faded back. He pulled back from it, so it's interesting.
That is interesting. All right, this was a wonderfully enlightening conversation. I want to thank our guests and thank all of you, and we'll see you at the next Trials and Errors. We have, I want to thank, before we go, Thomas and Rosie and Jonathan and Tom. Send them a warm welcome. Folks.org for our next programming, folcs.org. Thank you all.